Federal oil and gas leasing near national parks faces legal challenge. A coalition of environmental organizations, including the National Parks Conservation Association, has filed suit against the Department of the Interior and the Bureau of Land Management, challenging federal approval of oil and gas leasing activities near protected national park lands. The complaint argues that federal agencies failed to comply with the National Environmental Policy Act, NEPA, and the Federal Land Policy and Management Act, FLPMA, in approving leasing decisions. Specifically, plaintiffs contend that the agencies did not adequately analyze impacts to air quality, climate emissions, and visibility in nearby national parks. The lawsuit alleges deficiencies in the environmental review process, asserting that the agencies failed to take the required hard look at environmental consequences, particularly cumulative greenhouse gas emissions and downstream combustion impacts. The plaintiffs seek declaratory and injunctive relief, including vacatur of the leasing approvals. The case is narrowly focused on fossil fuel development on federal lands and its proximity to protected park resources. Why air quality and climate analysis are central blacks. A central theme of the complaint is air quality degradation and visibility impacts in national parks, issues that have long been legally sensitive under federal land management statutes. The plaintiffs argue that the environmental review did not adequately quantify or contextualize emissions associated with oil and gas development and downstream use. Climate impacts and cumulative greenhouse gas emissions are presented as key analytical gaps. This focus reflects a broader pattern in federal land litigation. Climate impact analysis is increasingly becoming the pressure point in court challenges to fossil fuel approvals. It is not simply whether development is allowed, it is whether agencies sufficiently evaluated the climate and air quality implications of allowing it. The operational exposure for energy companies. For companies operating in federal oil and gas leasing programs, the exposure is procedural rather than categorical. Federal leasing authority remains intact. However, environmental review sufficiency is increasingly subject to judicial review. If courts determine that environmental analysis is inadequate, potential remedies can include remand for supplemental environmental review, temporary project pause, vacatur of approvals. Even where leasing ultimately proceeds, additional review requirements can introduce schedule variability. For companies with drilling timelines, capital commitments, or investor communications tied to federal acreage, litigation risk becomes a sequencing variable. The issue is not outright prohibition, it is delay and additional review. The broader federal land signal. Federal oil and gas leasing has been a recurring focal point of litigation over the past several years. Courts have repeatedly been asked to assess whether agencies sufficiently analyzed climate consequences, cumulative impacts, and local environmental effects. This case reinforces that pattern. As administrations adjust leasing policy direction, litigation remains a constant mechanism of review. Environmental analysis tied to greenhouse gas emissions and park protection standards is likely to remain central in future challenges. For executive teams in upstream energy sectors, this creates a predictable tension. Policy shifts may expand or contract leasing opportunities. Litigation may independently influence execution timelines. The two forces operate on separate tracks but intersect in project sequencing. What this means for executive planning. Energy companies engaged in federal leasing programs should evaluate whether environmental documentation anticipates cumulative climate scrutiny, how potential remand scenarios are incorporated into capital planning, whether investor disclosures reflect litigation exposure, how drilling timelines align with possible judicial review cycles. Federal leasing does not occur in a static legal environment. Environmental review adequacy, particularly regarding climate and air quality, is likely to remain a focal point of judicial oversight. Approval does not eliminate exposure. It shifts the exposure into the courtroom. For companies operating on federal lands, that reality is now part of the planning environment. You've been listening to Sustainability Soundbites by Environment and Energy Leader. For partnership opportunities, please reach out to our team.